Lordship, this matter arises from an impugned judgment and order dated 12 to 2026, passed by the learned additional district judge in Miss Appeal number 25 of 2022, whereby the learned appellate court was pleased to affirm the eviction order passed by the estate officer, Lordship.
Yes.
Now, Lordship, in this case, Lordship, I am a bona fide purchaser of a plot of land where I am residing, having constructed a G+2 residential building. As such, I am in continuous possession since last 2026.
Okay.
And in the
Mr.
year of,
Gogoi, you are appearing in this matter? Okay.
in the year of 2023, a notice was served upon me, and accordingly, I filed an appeal. Subsequently, I filed an appeal. Now, this appeal, Lordship, was predominantly based on the findings of the estate officer, whereas estate officer did not conduct any conclusive demarcation or boundary to boundary comparison, Lordship. Now, the learned appellate court further compounded that error, having placed the having descriptive on the basis of descriptive reference in paragraph number 3 of my memo of appeal, where it pertained to the geographical location and proximity of the railway alignment. It was misconstrued as a admission of boundaries of my sale deed, Lordship. So therefore, Lordship, my appeal, my revision here, Lordship, is on the ground that there has been a misreading, as well as the learned appellate court, on the basis of presumption without any admissible proof, had passed the impugned judgment. On that basis, I'm before your Lordship, amongst other ground.
Now the question is, you have filed a reply to the notice given by the estate officer, right?
Now, Lordship,
You have filed that reply?
yes. Now, Lordship, what happened is, in 2020,
No, you answer my query.
yes.
Did you file your reply?
Reply to the estate officer.
Yes.
Estate officer, Lordship, it was on that ground, on Lordship.
In one word, you filed or not filed?
Lordship, I filed my written statement while the first notice was being served to me.
Okay.
Now,
whether you have enclosed the sale deed?
Yes, it is there. If your Lordship comes to the impugned order.
But whether the complete description, the complete deed of this sale deed was enclosed with your reply?
Yes. In the reply, the complete sale deed was placed before the estate officer, and the records of the estate officer was before the appellate court. Now it is on the paragraph of number 3, wherein I tried to describe the location of the railway alignment to my plot of land. It was misconstrued. I have already stated, Lordship, it was misconstrued that it was my boundary admission. Whereas, Lordship, there was no boundary to boundary comparison or technical verification being conducted. It is on a finding, the learned estate officer, Lordship, hastily passed an order in one single sitting, Lordship, based on the internal plans. But whereas there are no cogent materials, Lordship.
See, there is a definite finding of the appellate court that the land presently in occupation of the present petitioner is not the same land as described in the sale deed dated 9/5/2016.
Yes.
How do you answer it?
Yes, on that point, Lordship, on the basis of the registered sale deed, Lordship, I was handed over possession.
Whether that sale deed is a part of this record?
Yes, it is part of this record, Lordship. Lordship, it is here. I have
Page number?
Lordship, if comes to page number 32, Lordship, running page 32. This is my sale deed number 4691, Lordship. This is my deed of sale, the registered deed of conveyance, on the basis of which I am claiming my bona fide title over the land with specified boundaries, Lordship.
And where is the written statement filed by you to the state officer?
Eastern officer, Lordship. Lordship comes to page number 54, Lordship. 50. Yes. Now, Lordship, if I may be allowed to place one very pertinent point here.
Yes, what pertinent point?
Yes, Lordship, at the first instance, Lordship, while the estate officer served us the notice of requiring us to show cause, Lordship, there the schedule which they had incorporated was shown at Amingao, Lordship, at Silasinduri Gopal, Lordship. If your Lordship comes to the first impugn notice, it is here in the record, Lordship. Yes, Lordship comes to page annexure 7, Lordship. This was the first notice.
Page number?
53, Lordship. 53. Annexure number 7, Lordship. If Lordship comes to the schedule, it was shown at the first instance at Amingao, Lordship. Whereas my land was situated at Mas Jalukbari. Now, what happened is, Lordship, while the said impugn notice was served to us, we approached before this honorable court, challenging the said notice, and on motion, Lordship, this honorable court was pleased to pass direct an order of status quo in respect of the land possessed by the petitioner, Lordship. And that order is annexed at page number 69, Lordship. Page number 69. Yes. At page number 69, 66, Lordship. Case number WPC 122 of 2021, Lordship.
No, that WPC was later on dismissed.
No,
And
no.
the interim order was vacated.
Yes, yes. It was on the first instance, Lordship. While they served us the first impugn notice, the schedule was shown as at Amingao. Therefore, we approached this honorable court challenging the said notice that the land purported to be evicted is located somewhere else. It is not the land which under the revenue village where I am possessing, Lordship. Therefore, Lordship, this honorable court was pleased to direct an order of status quo in respect of the land possessed by the petitioner. Subsequently, Lordship, in exercise of power, section number 8 of the Public Premises Act, Lordship, the schedule was amended. The schedule was amended and a second impugn notice was being served to us, Lordship. And the second impugn notice, Lordship, if comes to page number 70, annexure number 14. While this order of status quo was in operation, Lordship, they amended the said notice under section 8 of the Public Premises Act, and accordingly they served us the impugn notice, whereby they corrected an amendment schedule was being incorporated there. Now this schedule here which they have placed is on a certified plan sheet number 82. Lordship, this is an internal plan of the railway authorities. Now what happened, Lordship? Here the hearing was conducted and accordingly the impugn order dated 17/2/2021 was passed, Lordship. On one single sitting, Lordship, despite the documents we had placed earlier before the estate officer, without conducting any verification or demarcation, or any technical verification, Lordship, the impugn order was passed. Therefore, we also preferred another writ petition, but since there is an alternative remedy under Section 9, the Honorable Court directed us to file an appeal before the London Appellate Court below, and accordingly we filed, Lordship. And if Lordship goes through the judgment, there were other materials also as regard to the RTI replies, Lordship, maps which we have relied, Lordship. Now, Lordship, without any boundary to boundary verification, Lordship, on presumption, without any admissible proof, Lordship, the impugned judgment and order was passed, Lordship.
Yes, Mr. Gogoi.
Lordship, first of all, Lordship, they have annexed the written statement filed by us in the Lordship lower court, trial court, Lordship.
They have?
They have not annexed the written objection filed by us against their appeal before the lower court, Lordship. It was not annexed yet, Lordship. Otherwise, also I am submitting, Lordship.
The copy is with you.
Copy is with me, Lordship, but full copy is not that they have sent it to my mobile, Lordship. That's it. In WhatsApp. Otherwise, Lordship, I am submitting, Lordship. My Lord, may kindly peruse page 70, Lordship. Page 70.
Yes.
Page 70 of the corrected sheet of the notice, Lordship.
Mm.
So my Lord, may kindly come to the schedule part, Lordship.
Yes.
Schedule part, railway land plot long so and so, Lordship. It is in certified plan long, plan sheet of 82, Lordship, Moja Jalakbari, Village Middle Jalakbari, Kamru Metro, Lordship, and it is bounded by, Lordship, north railway land, east railway land, and south railway land and private land, Lordship. My Lord, may kindly mark it.
Mm.
Then my Lord, may kindly come to, Lordship, page 27, Lordship. Page
27.
27, schedule of the property was purchased by the petitioner. Page 27.
Page 27 of the.
Page 27 of the petition, Lordship.
Okay.
Page 27.
Okay.
Lordship, got it, Lordship?
Yes.
It's a Lordship NOC issued by the Lordship Gauhati Metropolitan Development Authority, Lordship.
Mm.
My Lord, may kindly mark the schedule of the plot, Lordship.
Mm.
North, Lordship, 28 feet wide college road, Lordship.
Mm.
Then south, land of Lordship Akhtar Hussain, Lordship.
Mm.
Then east, Lordship, land of KK Hendrik Sanskrit College, Lordship.
Mm.
Then Lordship, west, land of Hemanta Das, Lordship.
Mm.
Then my Lord, may kindly come to page 39, Lordship.
Mm.
Page 39 is a part of the Lordship sale deed,
Mm.
and the schedule property is described here.
Mm.
Then my Lord, may kindly come to that bounded by Lordship that part.
Mm.
It is exactly to the Gauhati Municipal Development Corporation, Lordship,
Mm.
that boundary. North east, Lordship, 28 feet. My Lord, may kindly mark it.
Mm.
28 feet wide college road.
Mm.
South land of Akhtar Hussain, Lordship.
Mm.
Then east land of KK Hendrik Sanskrit College
Mm.
and land of Hemanta Das, Lordship.
Mm.
This is the land which is bounded by the petitioner's land, Lordship. Then my Lord, may kindly come to page 91, Lordship. Page 91, Lordship.
Yes.
Page 90, Lordship. Page 90, it's a section 9 petition preferred before the Honorable District Judge, Lordship.
Mm.
Paragraph 3, Lordship.
Mm.
The location in which, my Lord, may I read it, Lordship?
Yes.
The location in which the appellant said Miatipatta plot of land is situated on its eastern side a Bodgos railway line, Lordship.
Mm.
Completely, they have occupied a defined plot of land, Lordship, which they have purchased, Lordship. In the eastern side of the purchased plot of land, Lordship, it is in page 27, Lordship.
Mm.
It's a KK Hendrik Sanskrit College, Lordship.
Mm.
Eastern side, Lordship.
Yes.
Then Lordship, Bodhgos railway line is there, which was originated from Gauhati Kamakhya railway station to Goalpara Lordship. Then my lord skip that portion Lordship. Then my lord may kindly come to next page Lordship. Second paragraph Lordship. On the further southern side is the campus of the KK Henry Government Sanskrit College. In the southern side, land of Akhtar Hussain, the original Sildit Lordship. And which is a pioneer famous institute for imparting education of the Sanskrit literature language, entire Northeast. On the northern side, appellant lands in the public road. Public road is Lordship. There in the northern side, it was the 28 feet wide college road, original Sildit Lordship. Then Lordship, in the northeast side campus, Cambridge Educational Trust Lordship. In North Lordship, there the white college road is there Lordship. So Lordship, the land which was occupied by the petitioner is a different plot of land which was purchased by the petitioner Lordship. It's a railway plot of land. It is within the 39 meter from the middle of the Bodhgos land Lordship. Now Lordship, that particular land is Lordship required Lordship for extension of the double decker land from Lordship Nunmati to Lordship Goalpara Lordship. It's a public interest project Lordship. Last public interest is involved here Lordship. The land is purely railway land Lordship. The descriptions and sale deed is totally different and occupied land is totally different Lordship. And honorable court finding is also there. My lord may kindly come to. The findings of the Lordship, the honorable court's Lordship, it is cards from Lordship. Page 143 Lordship. I will paragraph 12 onwards Lordship. Otherwise also findings part Lordship may kindly directly come to page 150 Lordship. Paragraph 24 onwards I read it, if Lordship permit. The respondents, on the other hand, contended that the appellant is an unauthorized occupant of the railway land measuring so and so square meter described in the corrected amended schedule issued by notice dated so and so Lordship. The respondents have further contended that the railway land has been certified by the deed and deputy commissioner and collector Kamrup Gauhati and the then circle officer Gauhati Revenue Circle Mondol and another so and so Lordship. And that the railway boundary is marked at 39 meters from the middle of the track from both sides, eastern and western side, which is shown in the state certified plan sheet number 82. Then my lord 25 Lordship. The appellant has relied on the registered sale deed dated so and so, the mutation order and the Jamabandi to establish his title and possession over the land. However, respondents have pointed out the significant discrepancies between the boundary of the land as described by the appellant in the appeal and the boundary mentioned in the sale deed dated so and so Lordship. Accordingly, the appellant own case as pleaded in paragraph 3. My lord may kindly mark it. Of the appeal, the boundary of the land, his occupation is as follows Lordship. On eastern side, a Bodhgos railway line. On southern side, the campus of KK Henry Government College. On northern side, public road. However, the boundary is described in paragraph 27. However, the boundary is described in the sale deed dated so and so is as follows. North 28 feet wide college road, south land of Akhtar Hussain, east land of KK Henry Sanskrit College, and west land of Hemanta Das College. Then Lordship, paragraph 28. That these discrepancies in the boundaries are glaring and significant. The appellant has not been able to satisfactorily explain the discrepancies. The eastern boundary, as per the appellant's own admission, is in appeal is a Bodhgos railway line, whereas as per the sale deed, the eastern boundary is a land of the KK Henry Sanskrit College. This clearly indicates that the land presently in occupation of the appellant is not the same land as described in the sale deed dated so and so Lordship. Then paragraph 29 Lordship. Lordship, I can take some water. I am not well Lordship. 59 Lordship. The respondent have rightly submitted that the appellant has suppresses the vital material fact by not submitting the complete copy of the certificate. So where the pages containing the schedule of the property has been suppressed, Lordship. Then 30, Lordship. Furthermore, appellant did not provide any schedule of the land which with a boundary in its objection dated so and so filed before the state officer as well as in the instant memorandum of appeal. This omission is significant and indicates that the appellant is aware that the land presently is in occupation is not the same land as described in the sale deed, Lordship. Then paragraph 31, Lordship. The respondent have placed the record of certified land plan sheet so and so, which was jointly signed and sealed by the deed and deputy commissioner and collector Kamrup Gauhati, and then circle officer Gauhati Revenue Circle Mandal and another on so and so. The said certified plan sheet from so and so clearly shows that the railway boundary is marked at 39 meters from the middle of the track for both sides of eastern and western, and the diagonal so and so is shown in the said certified plan sheet is so and so. The appellant has also alleged that the imping order was passed in violation of the principles of natural justice, that the appellant was not given the proper opportunity of hearing. This contention is devoid of merit. The record clearly shows that appellant was given adequate opportunity of hearing. A notice dated so and so was issued to the appellant under so and so, calling upon him to show cause on so and so lawsuit. The appellant appeared before the state officer and so and so, filed that objection, submit along with the documents. During the hearing on so and so, this came to the notice of the state officer. Schedule land is question is incorrect. According to the railway authorities, corrected and amended the schedule land lawsuit. Then 33 lawsuit. Thereafter, a notice dated so and so was issued to the appellant under section so and so and calling him to attend and appear before the state officer and so and so for hearing with all relevant documents record relating to the instant eviction case. The said notice was received by so and so, wife of the appellant on so and so. However, the appellant did not appear for the hearing on so and so despite receiving the appropriate notice. The appellant neither turned up for hearing on so and so nor took any steps. In such circumstances, state officer was justified in passing the eviction order dated so and so. The appellant was also contended that the imping order was passed without examining the relevant records maintained by the circle officer, Director of Land Records, Government of Assam, and without involving concerned state government. The contention is also without merit. The state officer was relied on the certified plan sheet number so and so, which was jointly signed and sealed by the deed and deputy commissioner and collector Kamrup Gauhati, and then circle officer Gauhati Revenue Mandal, and another on so and so. This is a sufficient compliance of the requirement of examining the relevant revenue records lawsuit. The appellant has further contended that the imping order is initiated by the doctrine of colorable exercise of power, bias, arbitrariness, and unreasonableness. This court is find no merit in this contention. The imping order has been passed after due consideration of the material on record and after giving adequate opportunity of hearing to the appellant. The order is based on the cognate reasons and is in accordance with the provisions of this act lawsuit. Then also the appellant has also raised a issue with the railway has never acquired any land from the revenue blessed Jalukbari, Gauhati, and therefore they cannot claim that it is their land. However, this contention is contradicted by certified land plan sheet so and so, which clearly shows that the railway land exists in that area and the railway boundary is marked at 39 meters from the middle of the track for both sides, eastern and western also. The appellant has further contended that the land in question is urgently required for the railway development program, double line track, and that the decision to lay the new railway line on the left side of the existing railway line was taken for extraneous consideration and not the bona fide for technical reasons. However, the courts find that these are matters of policy and planning which are within the exclusive domain of the railway authorities. This court cannot sit in a judgment over the policy decision of the railway authorities lawsuit. Then also, appellant has also placed reliance of the fact that the repetition summons was filed before the Honorable Court, challenging the actions of the respondents railway authorities, and that the Honorable Court by order written summons directed to maintain status quo in respect of the land under law and under the lawful possession of the appellant. However, it is pertinent to note that the Honorable Gauhati High Court by order written summons was pleased to dismiss the repetition summons as infractious and vacated the interim order passed earlier. Therefore, the appellant cannot derive any benefit from the interim order dated so and so lawsuit. 39 lawsuit. Thus, in the present case, respondents have established that the land in question is a railway land and is therefore public premises within the meaning of the section 3 of the Act. The appellant has failed to establish that he has any lawful authority to occupy the said land. The discrepancies in the boundaries as described by the appellant in the appeal and as I mentioned in the sale deed clearly shows that the appellant is an occupation of the land which is defined from the land purchased by him by sale deed dated so and so lawsuit. This is the findings of the Honorable Court. On the basis of that lordship, learned court has decided that lordship, the petitioner is a unlawful occupied of the state, railway premises lordship. And lordship, it is an admitted fact that lordship still did the boundary demarcated in the cell deed. Boundary which was lordship shown in the cell deed is totally different. And lordship, the appeal which was under section 9, the boundary is totally different, lordship. And our case is that lordship, we need that particular plot of land lordship for as a construction project lordship, which is the double decker railway line case. Then only that portion it was stopped lordship. Other from lordship Walpura it is coming lordship, only middle portion it was stuck lordship. A double decker land and lordship, it's a project of national importance lordship. And petitioners, we are not encroaching the petitioner's land lordship. The cell deed which was described by the petitioner, we are not entered the land lordship. We are not entered that particular land. We are entered the land which is within the 39 meters of the railway track lordship. And the description is already we have given lordship. The description given by the petitioners in the appeal and the cell deed also totally different lordship. With the lordship, the regarding boundary lordship, Honorable Apex Court has time and again reiterated, I will place two things judgment lordship. Regarding where there is a conflict of the boundary which was shown in the cell deed is prevailed lordship. If we, for a moment, if we assume that lordship, there is a conflict, there is a contradiction regarding the plot of land and boundary line lordship. Then also Honorable Apex Court says that the boundary which was given in the cell deed is prevailed lordship. And petitioner purchased somewhere land and they have occupied somewhere land lordship. So if lordship found it, I can press this argument. It's in that particular point.
Now, Lordship,
Mm,
here if Lordship for a
Let him
moment.
complete.
Yes, Lordship.
Yes.
One of the recent judgment of the Honorable Apex Court lordship. 2025 SSC online SC 522 lordship. Here I am relying lordship paragraph 10 and 11 lordship. Although I am relying paragraph 10 and 11, I just indicate two lines from the paragraph 11. I will not must take time lordship. The if lordship I mean I can read paragraph 11 lordship.
Mm,
The plaintiff and the defendants raised the case through Mariamal. In this case, the plaintiff that the Mariamal sold an extent of 21 cents within the boundaries described in the cell deed, as could be noted and appreciated from the commissioner's report. 1/4 of the cent is the disputed property. The High Court failed to appreciate that to deny enjoyment of the actual possession of the so and so. The boundaries of the cell deed play an important role. Madam, kindly mark it, lordship. Then lordship, I am declaring another judgment lordship. It is 1963 SC lordship 1879 lordship. Here lordship paragraph 6 lordship. The closing appeal, the learned counsel for the respondent does not ask to go beyond the sale certificate and the final decree for sale. His contention is that there is a mere misdescription of the plot number in the two documents and that the identity of the plot shown clear from the circumstances which we have already set out above proceed. He relies on so and so. In that case, that the head happened was that the judgment debtor owned a mahal in which the 10 owners share was mortgaged while the remainder was free from the encumbrances. A creditor of his attached and put up his sale 6 owners share out of the mortgage sale. The property attached was sold. When the auction purchasers applied for the sale certificate, they alleged that a mistake had been made in the schedule of the property to be sold and the word not have been omitted from the description in the 6 owners share and that the property should have been described as being 6 owners not mortgaged. The pair of there was allowed by the executing court and the appeal. The High Court has failed to and appeal the Privy Council. It was held that the judicial sale only the property attached can be sold and the property is conclusively described in and by the schedule to which the attachment refers, namely the 6 owners share subject to the existing mortgage. The Privy Council therefore allowed the appeal and observed that a case of misdescription could be treated as a mere irregularity, but the case before them was the case of identity and not the misdescription. It was pointed out that property fully identified in the schedule may be some respect misdescribed and which could be a different case. Thus, the effect of the decision is that where there is no doubt as to the identity and there is only misdescription, that could be treated as a mere irregularity. Another case on which reliance has been placed on behalf of the respondents, so and so, so and so. In that case, the land sold was described by boundaries and areas, but the area seems to have been incorrect. It has held to be a case of misdescription of the area, and boundaries were held to be prevailed. So, Lordship, the boundaries which was earmarked in the sale deed will be filled. We even in misdescription also there, Lordship. By relying the Lordship 1963 Honorable Supreme Court judgment, Lordship, recently Honorable Madhya Pradesh High Court Jabalpur bench also passed another order, Lordship. Thus, I am relying paragraph, Lordship 9 and 10, Lordship. Paragraph 10 reiterated the dictum given by the Honorable Apex Court, Lordship, in Sarjan Singh case, Lordship, and paragraph 9 I read it, Lordship. It is well established principles of law that when there is a discrepancy with regard to the identity of the land, then the boundaries mentioned in the sale deed would prevail. If the defendants were of the view that wrong boundaries have been, that part is not required, Lordship. Here, Lordship, it is well established principles of law that when there is a discrepancy in regard to the identity of the land, then the boundaries mentioned in the sale deed would prevail. So, Lordship, our case is that the boundary which is prescribed in the sale deed, Lordship, we never touch that particular land, Lordship. At no point of time we have touched that particular land, Lordship. The boundary is very specific, Lordship. And the boundary which is described in the sale deed is a totally different boundary which is described in the appeal, Lordship. And Lordship, it is in their admitted case that they have in the southern side, it is a railway borders line is there. But Lordship, the land which is purchased, Lordship, the boundary is not there, Lordship. Totally defined boundary they have occupied, Lordship. So it is my humble submission before your Lordship that the railway will never encroach the land, Lordship, which was purchased by the petitioner, Lordship, in that particular sale deed. We are deal with the land which is within the 39 meters of the railway track, which is a totally defined boundary. This is my submission.
Yes,
If I may allow, Lordship. Now, Lordship, the proceedings under this act is a summary proceeding, Lordship. So first aspect which I would like to raise before your Lordship is that the judgment which they have relied, my learned friend just now have relied certain judgment regarding the boundary description. In that aspect, Lordship, how can a boundary description be proved, Lordship? Now here, while I placed my registered deed of conveyance before the estate officer, Lordship, I specifically stated that I have been residing within the specified boundaries of my sale deed. Now, Lordship. Now they have to counter that contention. They have raised that we have been possessing some other land. Now, if we are possessing some other land there, Lordship, then whose land we are possessing? They are not unable to show that. Now, secondly, Lordship, one aspect, while I am now possessing the land under the said registered sale deed, Lordship, I have been duly mutated in the records, Lordship, and I have been paying the revenue taxes. Now, Lordship, if for a moment comes to page number 59 and annexure number 9, Lordship, this is a very important aspect, Lordship, which I would like to raise before your Lordship. Here at page number 59, this is a letter being written by the Gauhati Circle Officer of the Gauhati Revenue Circle to the Joint Directors of Survey Assam, Rajanagar, Dokhin Gao. Now the subject here is the joint verification of identification and demarcation of plot of land, reference to a 55 to the double line project, Lordship, which was proposed to be laid in the at Mas Jalukbari, Lordship. Now, Lordship, here copies have been served to the principal KK Handik Sanskrit College, principal Cambridge Public School, Sri Ashwini Besborua, myself the petitioner lordship, State Women's Center, Zakir Hussain, Akbar Hussain, and the concerned Latmandal and the SK lordship. Now here the names which have been written down to whom the copies were served, all of them have been served notice lordship. Now they are my neighbors lordship. Now lordship here, the Cambridge Public School, which is a CBSE affiliated school lordship, how can that be treated as an unauthorized occupant? They have purchased the land. Subsequently, he is my neighbor. I have purchased my land there. I have duly mutated lordship. In the records, if lordship comes to the annexure 4, page number 41, lordship.
So how this annexure 9 will help you?
Yes, lordship.
Well,
Yes,
there is
yes,
a
yes, yes.
discrepancy in your own document in the appeal filed by you
Yes,
under section 9.
yes,
How do you explain it?
yes. In that aspect, lordship,
Mm,
now the judgment passed by the learned appellate court below, lordship,
mm,
was predominantly opined on the selective reading of para number 3,
mm,
lordship. Now, para number 3, I propose to explain the geographical location and proximity of the railway alignment,
mm.
lordship, for which I was served notice of show cause under the Public Premises Act, lordship. They have denoted me that I am an unauthorized occupant, lordship. Now, whether I fall within the meaning of unauthorized occupant as written down as defined under the said act, lordship. Now, lordship, here they have now, lordship, in para number 3, while I have explained the geographical proximity, lordship, it was misconstrued as an admission of boundaries, but nowhere in paragraph number 3 I've stated about my sale deed, lordship. I propose to explain the corners of the railway alignment, lordship, it in reference to the railway alignment. It was misreading of the pleadings on the basis of which the impugned judgment was passed. And lordship, regarding the acquisition part, in the RTI reply, it was not taken into account while passing the judgment. The lordship comes to annexure number 11 at page number 64, lordship, and 65, lordship, annexure number 2, annexure number 12, lordship. Annexure number 12, lordship, for a moment, at page number 65, lordship, at question number 5, at the bottom part, lordship. NF Railway doesn't require any further land in Mas Jalukbari, as NF Railway have already acquired land for modified alignment on LHS of the existing railway track up to 39 meters from the central line of existing railway track as per certified plan sheet number 82 of Moja Jalukbari district, Kamrup, lordship, Kamrup, copy of which enclosed herewith for ready reference. Now, I fall within the jurisdiction of Kamrup Metro, lordship. Now, they have consistently relied upon a plan, internal plan, as certified plan number 82, on the basis of which they are telling that we are unauthorized occupant. If, lordship, I have been possessing some other land, lordship, to the contrary to the fact that if I am not actually possessing my own land, then why my name has been mutated, lordship? If I am possessing some other land, lordship, then definitely there would be a dispute of title. And over and above, lordship, matters pertaining to complex title dispute are beyond the purview of the said act, lordship. Now, lordship, on the basis of para number 3 only, lordship, the whole judgment was opined, lordship. It was nowhere it was reflected, nowhere, lordship, any descriptive pleading has been made regarding admission of the sale deed boundaries, lordship. It was misreading of pleadings, lordship, and without any technical verification, how can they?
No, you tell me
Yes.
whether the observation made by the appellate court is not there in the paragraph number 3.
Lordship, now paragraph number 3, lordship, the appellate court, on the basis of paragraph number 3 only has passed the judgment. Now, but the lordship, in the impugned order
No,
passed by the
you
state
tell me
officer.
whether the observation made by the learned appellate court is not there in the paragraph number 3 of your memo of appeal.
In the paragraph number 3, it is reflected, but in the while in the course of hearing, lordship, we consistently placed that, lordship, it was in respect
Whether
of.
you have amended that pleading.
No, we
before
have
the
not amended
appellate
because
court.
amended, lordship, it has arised from an impugned order passed by the estate officer, lordship, but the estate officer, lordship, in its finding, if Lordship comes to the impugn order of the estate officer, nowhere it is written that we have been possessing some other land or there has been any boundary overlap. Without technical verification or demarcation, Lordship, how can the appellate court reappreciate such facts, Lordship? That is one aspect, Lordship, which I am raising. It at Annexure 16, Lordship, page 76, Lordship. On one single sitting, Lordship, impugn order of eviction was passed. No,
How many sittings are required?
Lordship, in
How many sittings are required as
Lord-
per law?
as per law, Lordship, on that aspect, I'm unable to answer that.
Then
No, Lordship, I'm sorry, Lordship, but here, while I place my materials, Lordship, because my registered sale deed is there, without nullifying or the sale deed, Lordship, how can I be treated as an unauthorized occupant, Lordship?
the sale deed has never been nullified by the learned appellate court. It has relied upon it.
Yes. Now it was
And
misconstrued.
as per the judgments referred by Mr. Gogoi, also, sale deed has to be considered as the document
Yes.
to be relied upon.
But Lordship, to the contrary, if it has to be proved, then evidence has to be laid, Lordship. Evidence has to be laid that there is, because Lordship, on the basis of the registered sale deed, on the NOCs issued by the state authorities, Lordship, I possessing the land, I have been mutated. Without examining that officials, how can it be treated that I have been possessing some other land, Lordship? And for that purpose, only demarcation and identification was be that letter, that communication at annexure number 10, I have placed, Lordship. No conclusive findings, no conclusion was arrived at, Lordship. And while the matter pertaining to the first writ petition before this honorable court was pending, Lordship, they amended the schedule and subsequently, Lordship, passed the order of eviction, Lordship, while the matter was before the honorable court.
No, we are not concerned with that aspect.
Yes. Now, Lordship, in respect to annexure number 10, Lordship, while they tried to, in reference to the double line project, Lordship, identification and verification of plot, Lordship, communication was issued. No conclusive finding was when arrived at, Lordship. If there would have been any finding that these person are not possessing the actual land.
No, Mr. Counsel, you see, here in this civil revision petition, we are testing the correctness or otherwise of
Yes.
the order passed by the learned
Yes,
appellate
yes.
court. We will not go beyond that.
Yes, yes. On that part only, Lordship, I have raised the grounds, Lordship. For the moment, if I be allowed to read the grounds, Lordship. There I have, on the basis of the perverse finding, Lordship, reappreciation of fact, presumption without proof, Lordship, I am before this honorable court. And Lordship, if comes to page number 14, the grounds, Lordship. Page number 14, the grounds which I have raised, because, Lordship, here we have to be very much specific in respect of what we have raised. And for that, the learned appellate court has gravely erred in treating the descriptive recital in paragraph number 3 of the memo of appeal as categorical admission of boundary and in equating such geographical description proximity with the boundary schedule contained in the registered sale deed dated 9/5/2016. Further was reference to the railway line, Lordship. Reference to the railway line and the adjoining institution was merely descriptive of geographical surroundings, proximity, and not intended as boundary schedule superseding the registered sale deed. Now, ground number 2, Lordship, the learned appellate court below failed to appreciate that the legal identity of the immovable property is determined by the boundaries scheduled in the registered instrument and correlated revenue statutory documents, and as such, without taking in account or undertaking any demarcation, measurement, cadastral correlation, or boundary to boundary comparison through competent authority, the learned appellate court below presumed discrepancy and infer change of land, thereby recording finding based on inference rather than evidentiary determination. The further observation regarding LS suppression of sale deed in 9/5/2016 is equally misconceived in absence of judicial findings of fabrication of inconsistency in the registered instrument. The entire reasoning thus proceeds on misreading of pleadings, misapplication of judicial man and presumption in place of proof, rendering the impugned judgment and order dated 12/2/2026 legally unsustainable, perverse, and liable to be interfered, Lordship. Now, in ground number 3, Lordship, for that it is the accepted law that the pleading must be read in whole and construed harmoniously. not by isolating stray expression out of context. The learned appellate co below gravely erred in selectively relying upon the descriptive references contained in paragraph number of 3 without reading in conjunction of other documentary records forming part of memo of appeal. Such fragmented and selective reading forms part of misreading of pleading, non-consideration of materials on record, thereby rendering the impugned finding perverse based on incomplete appreciation of records and legally unsustainable in exercise of appellate jurisdiction. Therefore, the impugned judgment and order dated 12/2/2026 is liable to be interfered by the Honorable High Court. In 4 Lordship, for that the proceedings under the Public Premises Eviction of Unauthorized Act 1971 are summary in nature and limited in scope. The learned appellate court lacked jurisdiction to adjudicate disputed question of title and boundary identification by drawing inferential conclusion from pleadings. The impugned judgment, instead of confining itself to limited inquiry contemplated under the Act, effectively undertakes a determination of the title and boundary correlation without any proof, demarcation, survey report, or evidentiary trial. Therefore, the learned appellate court below.
In which part of the judgment the appellate court has decided the title? Which part?
Now, Lordship, here at para number 39 and 40, Lordship, at page number 156 and 157.
Yes.
In para number 40, Lordship. Lordship, the earlier paragraph number 39, if I may allowed to read out. Here, Lordship, the respondents have established that the land in question is a railway land, is therefore public premises within the meaning of section 2E of the Act. The appellant has failed to establish that he has any lawful authority to occupy the said land. Discrepancy in the boundaries as described by the appellant in the appeal and as mentioned in the sale deed clearly shows appellant is in occupation of land which is different from the land purchased by him. White sale deed dated 9/5/2016. The appellant has failed to explain the discrepancy satisfactorily. Now, Lordship, in this paragraph, Lordship.
So is it determination of type title?
In 40, Lordship, in paragraph number 40. It comes to paragraph number 40. The appellant's reliance on mutation order and jamamandi is no avail in the present case. The mutation entries in the revenue record do not confer title. It is well settled mutation.
Yes, that is the well settled proposition of law.
Proposition it has been laid, Lordship.
Does it mean that the trial court, appellate court has decided the title?
No, it doesn't mean, Lordship, but here it is in respect of the discrepancy of the sale deed boundaries, Lordship. Here, the boundaries, Lordship. Now, if I have been possessing some other land, Lordship, then how that aspect can be determined? Now, whose land I am possessing, Lordship, that has to be determined by the records, Lordship. Now, there is no conclusive record in the before the learned court below showing that I have been conclusively possessing some other land, Lordship, except for the pleadings.
No.
That
From
is the
your
reason,
own
Lordship.
pleadings, no. From your own pleadings, it is apparent.
Yes.
From your own pleadings, the learned appellate court has observed recorded the finding.
Yes, Lordship, but for Lordship, here one intricate aspect is involved. It is
What is?
Yes, that aspect is, Lordship. The reference was made to the railway alignment, Lordship. On that basis only, Lordship, the pleading was made that the north, south, western side, even the further southern side also was mentioned, Lordship. But there is no categorical admission regarding the boundaries of the sale deed in paragraph number 3, Lordship. Nowhere. That is my case, Lordship.
No, that is your document. Sale deed is enclosed by you.
Yes. But I didn't admit, Lordship, that I have been not possessing the land specified in the
Maybe, but from your pleadings, it appears that you were
Yes.
occupying a different plot of land.
Yes,
Which
it
is
is on
different
the
from the
yes.
sale deed.
Lordship. Now I am possessing a land, Lordship. Now I am possessing one land, Lordship. Here I am residing since 2016, Lordship. After 4 years in the year of 2020, they served me an impugned notice, Lordship. First thing, the impugn notice scheduled as showed at Amingao Lordship.
No,
The
no.
second aspect, Lordship, that there exists one railway alignment. There exists one railway alignment, Lordship. Now, on the first issue only, Lordship, the proposed railway line was supposed to be laid down on the other side, Lordship. In the RTI, categorically it has been mentioned, Lordship, if it comes to the RTI, we put a question, Lordship. Because at the first instance, while I have been possessing the land there, in the
That
RTI,
RTA reply will not help you at this stage.
yes, but Lordship, the alignment was shifted from the right hand side to the left hand side of
We
the
are not concerned with that.
existing broad gauge. Now, reference I made to the railway alignment, Lordship, on the basis of with that only I have described my geographical surroundings, Lordship. There are no, because Lordship, I have been consistently submitting, Lordship, that nowhere I have stated that I have been possessing some other land. And Lordship, most importantly, Lordship, regarding testing whether I am possessing the land as per my boundaries or not, that has to be supported by other cogent materials such as demarcation, Lordship, identification, or boundary to boundary verification, Lordship. But nothing in the impugn order of eviction passed by the estate officer contain all those references, and the learned appellate court reappreciated the facts, Lordship, and passed the impute judgment and order, Lordship. And on that ground only, Lordship, we are here before you, Lordship. Because, Lordship, I have stated, Lordship, that I am residing as per my sale deed boundaries, Lordship. Now, Lordship, here if I would have been possessing some other land, Lordship, then there would have been a serious issue, Lordship. Till today, Lordship, nothing such question has arisen, Lordship. Only aspect is that, Lordship, on the paragraph number 3 only, while I referred to the adjoining railway line, Lordship, the learned appellate court opined that I have been possessing a land which is not as per my sale deed boundaries, Lordship. But that has to be determined by evidence, Lordship. Now, Lordship, in that aspect only, I am before your dishonorable court, Lordship.
Okay, we will pass the order.
Lordship, and I have referred, Lordship. I is also there, Lordship, along with that.
We will see whether we can admit this petition or not. Only thereafter the question of staying the operation of the appellate order will arise.
Yes, Lordship, but I had referred, at least till then, Lordship, any status quo order may be passed,
No.
Lordship. Because I have a case, Lordship, fit case, Lordship, for
Public
interference.
interest is involved.
Yes,
will
Lordship. I'm
Yes, next item.
Oh, fine.
May it please your lordships. Lordship, this is a transfer petition under section 24 of Code of Civil Procedure, whereby I'm praying for transfer of FC Civil number 472 of 2025 from the Learned Court of Principal Judge Family Court Kachar, Silchar to the Learned Court of District Judge Shribhumi. Lordship, the ground behind filing this transfer petition is that the petitioner herein has been staying at her parental home and her father does not have any such good source of income whereby she can travel from Shribhumi to Silchar on every single date when the matter is listed before the family court. Moreover, she has a
What is the distance between Shribhumi's petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transfer of FC Civil case number 472 of 2025 from the Court of Learned Principal Judge Family Court Kasar Silchar to the Court of Learned District Judge Shribhumi. Dr. Agarwal, Learned Counsel for the petitioner, submits that the petitioner is the wife of the respondent who has instituted FC Civil case number 472 of 2025 in the Court of Learned Principal Judge Family Court at Kasar, Silchar. She further submits that the petitioner is presently residing at her parental abode at Shribhumi and from Sivami to Kasar Silsor, though the distance is only no, though the distance can be covered only within a period of 1 hour only, yet the court is situated at such a place that it takes about 4 hours. 4 hours, and that the petitioner has an ailing baby and baby of 1 year old, and with that baby, it would virtually practically become impossible to undertake journey to Kasar Silsor to contest the FC civil case number 472 of 2025. And that this present petition is filed with the help of legal aid, and she is engaged by the legal service authority. And one more proceeding under section 125 of the Code of Civil Procedure, being Miss case number 84 of 2025, is pending before the Court of Learned Subdivisional Judicial Magistrate Sribhumi, and the said case was also filed through the District Legal Service Authority Sribhumi. Under the aforementioned facts and circumstances, Ms. Agora contended to transfer the FC civil case number 472 of 2025 to the court of from the Court of Learned Principal Judge Family Court Kasar Silsor to the Court of Learned District Judge Sribhumi. The submission of Ms. Agarwal needs further consideration. At this stage, issue notice to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. And pending further consideration. FC civil case number 472 of 2025 pending before the Court of Learned Civil Judge, Principal Judge Family Court Kasar Silsor stands state till returnable at least after 4 weeks.
Deeply obliged, Lordship.
One. Admission.
Yeah.
Lordship, by this petition under 227, the petitioner's limited prayer is that the order dated 18/7/2025 passed in Ms. case number 83, rejecting the petition under order 26 rule 9. Please set aside. Lordship, this suit was instituted by the sole respondents and his parents, alleging inter alia that the state authorities, district administration, demolished their boundary wall, northern side boundary wall facing National Highway 37 by digging a drain, widening the, cleaning that one, by thereby damaging the wall and some trees. The state could not contest the suit, file petitions. It was beyond the period of 90 days. As such, that was rejected. However, the state took part in the proceedings by cross-examination. Lordship, in this case, I committed a little wrong. In my petition before the Learned Appellate Court, I said that the state did not participate in the proceedings. I wrongly quoted that one because at that time I was not conducting cases on behalf of states. Therefore, I humbly pray that was my wrong. However, state contested the case by cross-examining the witnesses and taking part in the argument. Ultimately, suit was decreed against the states. Appeal was preferred before the Honorable High Court. On the point of pecuniary jurisdictions, this was transferred to the Learned Court of District Judge Kamrup Metro. During the pendency of appeal, and petition under order 26 rule 9 was filed by the state authorities, praying limited prayer only that let the matter be examined by spot verifications, not to collect information, not to give evidence, but to collect information whether the construction was carried out over the national highway land or not. Secondly, the suit, it was at the instances of national highway that was demolished. National highway was not made a party to the suit. There are other agencies, including GMC, GMDA, SP, police, all those things, they were not paid parties. Only state administration, district administration, that is DC, state, DC, and circle officer was made party. Ultimately, the suit was decreed against the state. My limited submission before this honorable court is that let there be a verifications. I am not going to collect evidence. Let us obtain the information whether that wall was constructed over the government land, that is your patta land, or otherwise government land or other national highway land. In fact, there will be no government land now. That is a land of national highway because it was acquired. And at the time of purchasing the suit land, it was only a two-way lane, national highway. Thereafter, 2006 onward, now it is at present 8-way national highway. Therefore, my submission before the honorable court that instead of taking permission for construction of constructions activities, GMD is not the only authority. It is the national highway also supposed to give obtain information from obtain permission from the national highway. So in this case, my immediate submission is that let there be inspection over the suit properties. If they have agreed, if he has suffered damages, we have to compensate him. If it is not so, if he has constructed beyond his land, over the national highway land, he cannot claim any benefits. And it was actually he is supposed to, from the documents, it is seen that it is the Act of National Highway 1956. Then the Control of National Highway Land and Traffic 2002 is applicable in this case. Even otherwise, presuming that it is state land, government land, even the notice under section 18 subsection 2 of Assam Land Revenue Regulation is no notice is required. Even in the case of National Highway, section 26 clearly speaks that supposed to issue notice should be issued. But that notice can, in the event of emergency, the notice can go off. Section 26 says Section 26, subsection 8, notwithstanding anything contained in the section, if the National Highway Administration or officer authorized by such administration on behalf of the opinion that any unauthorized occupation of the national highway land is such of nature that immediate removal of such necessary in the interest of safety and traffic of the national highway or safety of the any structure forming the part of national highway. My submission is that this a task force was constituted under the banner of National Highway to clear up the unauthorized constructions and to widening the drain alongside the National Highway in the year 2014. And as per that, the action was carried out on that particular day, 28/10/2014. Because very often there seems to be a sudden flood in the National Highway, causing public safety. Therefore, it was necessary to do so. So my submission is that National Highway Authority should have been an appropriate, National Highways should have been an appropriate authority under against whom the suit should have been instituted, not against only the district administration. So therefore, it is required in the interest of public safety, in the interest of public interest, it is necessary that let the suit property be inspected so as to collect information whether the plaintiff constructed this suit or the boundary wall in the northern, facing the northern side of the National Highway over the patta land or the government land. Only limited prayer.
So why the learned district judge has rejected your prayer?
It is only said that I am trying to collect the information, to lead evidence. I did not have the place. I did not have my written statement. I could not take part in the pleading by my own defense pleadings. Only thing I was able to, and in the cross examination, it was admitted. Before that, even in the plaintiff, in their suit, they are in their statements, section page at page 29, para 16 of the plaint, they prayed for page 29, page 29, para 16. This in order to assess the actual damage suffered by the plaintiff and also for enabling this court to appreciate the dispute in question, the local commission may be appointed by this honorable court for proper adjudication of the case in hand. And in their prayer at page 33, para 7, a local commission may be appointed in order to assess the actual damage suffered by the plaintiffs and also for enabling this court, honorable court, to appreciate the dispute in questions. It is not my case, it was their case. Even they wanted a commission. I did not have my defense pleading because I could not file my WS. I could not place the documents before the honorable court that it was a task force, including National Highway. It is not the district administration they constructed, they evicted the persons, plaintiff from the place, damaged the wall.
Yes, Mr. Kau.
First of all, I raise a preliminary objection as regards the maintainability of the CRP because this application has been shown by the circle officer, so without any authorization from the remaining two respondents, the state of Assam and the DC. So there is no authorization letter annexed with the civil division. Apart from that, my lord, we are confined in this matter. We are confined only with the order dated 18/7/2025 passed by the learned session district judge. My lord. We are not going into the merit of the case. And if my lord, the objection which I had filed and also before the learned sessions court, the district judge, my lord. It will be evident, my lord, they were given numerous opportunities to file a written statement, my lord. They had taken 1, 2, 3, 4, 5 adjournments, and only thereafter the order was passed for closing the stage of written statement. After that also, they had cross-examined the plaintiff witnesses, and they were also granted an opportunity to file a written article. So they had done all that, my lord. But they did not file any application for setting aside of the ex parte order. That they could have very well filed in the trial court itself, but they did not file. Only at the stage of appeal, when the case was fixed for hearing, then they had filed this application under Order 26, Rule 9, and also under Order 18, Rule 8. And the learned district judge has rightly passed the order dated 18/7/2025, my lord. If my lord may kindly peruse Order 18, Rule 3A of CPC, my lord.
Pardon?
Order 18, Rule 3A of CPC.
Order 18 rule.
3A of CPC.
this talks about when a party himself wishes party to appear before other witnesses. So the defendant, that is the state, ought to have brought their own witnesses before they can rely upon a commission, advocate for a commissioner. Because it says, well, when a party himself appears to appear as a witness, order 18 rule 3A, he shall so appear before any other witness on his behalf as has been examined, unless the court for reasons to be recorded permits him to appear as his own witness at a later stage. So this order 18 rule 3A has to be read along with order 26 rule 9, my lord. Order 26 rule 9 talks about the local commission. Commission order 26 rule 9, my lord. In any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute or of ascertaining the market value of any property or the amount of any mean profit or damage or annual net profit, the court may issue a commission to such person as it thinks fit, directing him to make such investigation and to report thereon to the court, provided that when a state government has made rules as to the persons to whom such commission shall be issued, the court shall be bound by such rules. And in that regard, my lord, the rules applicable in the state of Assam is the civil code rules and orders, my lord. There, if my lord may kindly peruse rule 230, my lord, civil code rules and orders.
Yes. Well, okay.
Otherwise, my lord can take this, man. It talks about as to why it could not have been done earlier. Civil code rules and orders talks about as to why the witness could not be brought earlier. So this has to be followed, my lord.
Which order you are referring to?
It's highlighted by
230.
number C. My submission, my lord, is that first of all, order 26 rule 9 has to be allowed only after the evidence of the parties have been read. They have to give evidence, then only order 26 rule 9 comes in, my lord. And secondly, my prayer, I had sought for local commission. That was at the stage of trials, my lord, at the trial court, not at the appellate court. They could have very well filed an application for setting aside of the ex parte order, which they have failed to do. They contested till the appellate, till the hearing stage, they had filed a written argument. There was no bar for them for filing an application for setting aside of the ex parte order, which they failed to do so, my lord. And my lord, I rely upon certain judgments, my lord. There are 4-5 judgments. Some of the judgments have been relied by the learned district judge, my lord. Nityanand Sutia, that judgment has been reported in 2025 5 GLT. The relevant paragraph is paragraph 18, 21, 23, and 24. It talks about, my lord, it helps, my lord, that the object of paragraph 18, my lord, the object of local investigation is not to collect evidence which can be taken in court, but to obtain evidence which from its very peculiar nature can be available on the spot. Then paragraph 21 talks about thus from the above provisions contained in rule 230 of the civil code rules and orders, my lord, it appears that the order directing issuance of a commission for local investigation should contain as to why such matter could not be proved or ascertained in the ordinary way by producing documents at the proper time and witnesses at the trial. Paragraph 23. However, nothing has been made in the petition as to why the said allegation could not be proved or ascertained in the ordinary way by producing documents at the proper time and witnesses at the time. In the impugn order also, there is more reflection as to why the matter for which commission has been issued could not be proved or ascertained in the ordinary way by producing documents at the proper time and witnesses at the trial. Para 24, it is a settled proposition of law that the purpose of local investigation under Order 26, Rule 9 of the CPC is not to fish out evidence for the parties where parties can themselves produce such evidence. It is only when the court finds that the parties themselves cannot produce evidence to that effect, the court will issue commission for local investigation. However, in the instant case, there is no indication in the impugn order as to why the respondent number 1 to 7 could not produce the evidence regarding the allegations made by them in that petition. Thus, in this case, there has been violation of provisions of contained in so and so while passing the impugn order. So this is 2025 matter. Then the other judgment where I had cited this judgment before the learned district judge. I'm just not reading out the entire portion, but the relevant paragraphs 2082 GLR. This is paragraph.
Okay,
11,
okay,
12, and 13.
not necessary to read out
Not
all these
necessary.
things. Okay,
These are the judgments.
yes, Mr.
Lordship, I have
Gauhati,
limited-
how do you respond to the same?
Lordship, I have limited submission.
Hmm.
Under order 18, rule 18,
Mm.
power of the court to inspect. The court at any stage of suit inspect a suit property or thing concerning which in question may arise.
Now we are in appeal.
Lordship, that is no problem. Even the suit is appeal is a continuation of the suit. also.
Mm.
So even the honorable court has the power to inspect it, and it is in the public interest. It needs to be inspected. Whether any construction has been carried out unauthorizedly over the government land or a national level land. One thing, in the interest of public safety,
No, why you have failed to
all right.
to exercise that power at the time of pendency of the suit
yes,
before the trial
Lordship.
court?
Lordship, in this case, in the year 2014, 15, 16,
Mm.
2015, there was a sub game in Gauhati, South Asian Federation game.
Mm.
Then there was an election in the year 2015.
Mm.
Then NRC update process was going on. All these officers were very much busy. All those
No, that cannot be the ground.
Lordship,
Sorry.
even otherwise also. In appeal, I shall submit three judgments of this subject also honorable Apex Court and MP High Court.
Mm.
Wherein in appeal also, order 26 rule 9 petition can be undertaken.
Mm.
Because my prayer is limited.
Mm.
I do not, if we have done damages to the properties
Mm.
to them over their patta land,
Mm.
we are bound to pay the amount.
Mm.
But if it is constructed over the government land,
Mm.
we are not. Because no notice under section 18 subsection 2 is required. And even order 20 or section 26 of 2002 Act, National Highway Act,
Mm.
permission is necessary.
Mm.
So my submission, it is not the GMDA permission allowed will do.
Mm.
It is the permission needs to be taken from the National Highway Authority also.
Mm.
Here in this case, a limited prayer, because I did not say so, that I did so much this thing. I did only to see that whether this was a boundary dispute, and with whom the boundary dispute, he is not a party to the suit.
Mm.
Boundary dispute with the National Highway, not with me. So National Highway Authority is a necessary party. That point is also not considered. Because
No,
National, it was,
you have not raised the issue before the trial court.
we, in cross-examination, we in our cross-examination,
Now we are concerned only with the order by which the learned appellate court has dismissed your pair under
Lordship,
order 26, rule 9.
9.
Rule 9.
I have another petition along with them, order 18, rule 18.
Yes.
Now,
Mm.
I leave with the three judgments. Only thing, my judgments, it was placed before the learned appellate court. It was written in the top. So I thought that I could not bring it because the supply was not there in the morning.
Okay.
Only thing, my little submission, it will be in the interest of public interest also, it is necessary. That
We'll
whether,
see.
and
We'll see.
One short reply, my lord. I think last year there was a judgment of the division which is given under 18. Notice has to be given to the persons who are affected. I'm not under that, but they are saying that no notice is required under Rule 18. But there's a judgment of the division bench, I think last year, that notice has to be given.
Even in this case, section 18 is not applicable even then, because it is section 26 of National Highway Authority Act is applicable. Because that land belongs to National Highway, not me.
If that be the case, my lord, the National Highway Authority should have come to the court, not.
Why they should come?
If
Because
they
you
are
made me
affected-
party, you made me party.
If they are affected,
Here,
my lord.
order has been passed
Okay.
against me.
Okay.
Order has been passed against me.
Yes, next item.
May it please, my lord. My lord, in this matter, I have been appointed as an amicus to assist the court. And my lord, it's a very voluminous records, my lord. I'll need some time to go through the records fully. Some little time may be given on and the matter may be fixed on a Tuesday or a Thursday, because this matter is going to take time.
May I please, Lordship? May I please, Lordship? I am petitioner in person. In the last order, this honorable court already withdraw the service of the amicus curiae, Lordship.
No, 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 no.
No, Lordship.
There is no such order.
No, Lordship, it was specifically mentioned in the order by mentioning my name only, Lordship. In earlier order, Lordship, and this honorable court specifically mentioned that there is no required to assist this court of amicus curiae, Lordship. It was specifically mentioned and it was already written, Lordship. There is an urgency, Lordship. That is why because last 4 months in the name of amicus curiae, I am suffering, Lordship. And last date, sir was not appearing in last date also, Lordship. This honorable court already withdraw the service, Lordship. It was specifically mentioned my name in the name of the petitioner in person.
No, Mr. Randip Sharma is appointed.
Lordship, in last occasion he was absent. That is why this honorable court in earlier occasion also the earlier amicus curiae was
No.
reluctant to continue the case.
The case was last listed on 12/12/2025, on which Mr. Sharma was
28
appointed.
last was 28/01/2026, Lordship.
Yes,
The honorable court specifically verbally mentioned that there is no required to
no, there is
service
no
of the
written
amicus curiae.
order.
That is not
Sorry.
the order.
Lordship, it was specifically mentioned my name, Lordship. Earlier, it was not specifically mentioned my name. In earlier order, can you refer to the earlier order?
No, in the order dated 28/1/2026, Mr. Sharma is not relieved.
Lordship, my name was mentioned in the order that Obinash Bora petitioner in person for the petitioner, because sir was not appearing. That is why this honorable court verbally mentioned that.
May I submit one thing, madam? My reputation here has been appointed as the amicus, not to represent Mr. Bora.
Yes, to assist the
To
court.
assist the court. So what the order sheet reflects who is appearing for the petitioner, whether it is the petitioner himself. or
It
not.
does not
That
matter.
does not remove Mr. Sharma from being the amicus, madam.
No,
With
that is-
utmost respect, madam.
my
By a
Yes.
subsequent order, the services of the amicus are withdrawn, and I have got nothing to say, madam.
but my humble submission is that
But it is very unfair on the
no,
part of
it
the
is not
petitioner
unfair,
to
Lordship,
say
because
he
he
has
was
withdrawn.
why he was so much interested. I don't know, because Lordship.
Sir, he is making personal allegations, madam.
No, I am submitting.
Might be personally.
No, I am submitting facts.
No, please.
He's making personal allegations.
No,
madam.
Lordship, this is not earlier
No,
occasion.
no,
also-
Mr. Counsel, you say, we'll take the matter on Tuesday. Yes, Mr. Sharma,
My lord,
Tuesday, next Tuesday.
my lord, my lord may give me 2 weeks. There's the 4 volumes
No,
of.
so already gave sufficient time, Lordship.
No,
Already
yeah,
gave sufficient time.
sorry.
There is an urgency, Lordship.
It is a matter between court and
I can-
amicus curiae, not between you and me.
The last
Short
time
date?
sir did not appear.
Short date, my lord, 2 weeks, man, 2 weeks.
No,
on a Tuesday.
no, 2 weeks. If the matter is urgent, then we'll grant you 1 week time.
This is a matter relating to dismissal of.
The removal from service.
Lordship, I have
Removal
already,
from service.
Lordship, I have already submitted a 8 pages document in my interlocutory application regarding the core subject of my writ petition. And sir already received the document 1 and 2 months back, Lordship. And sir was not appearing in the last occasion, Lordship.
Maybe.
And he,
Let it be on Thursday, March 5th.
5th is a holiday, my lord.
No, it is not a holiday.
It is not a
Can
holiday.
it be on the 10th, my lord?
10th.
5th, I have some difficulty. Can it be on the 10th?
Okay,
It's a Tuesday, my lord.
okay. Yes, any problem?
Lordship, kindly list my matter, considering the urgency of this matter, Lordship. Kindly, if this honorable court allow me to list the matter at the top of the list, because I am suffering from some difficulties, because it is not possible for me to sit here to throughout the day. Because if I'm finding difficulties towards the end of the day, it is not possible for me to.
Okay, on
Happy.
that day, on
Sir, can
10th of March, we will list
Top
the
of the list.
matter as top of the list matter. Yes, any objection? Heard Mr. A. Bora.
Yes.
Learned. No, Mr. A. Bora, petitioner in person, Mr. N. Deka, learned counsel for the respondent number,
I am for 2 and 3.
respondent number 2 and 3,
I am for 4, 5, and 6.
4, 5, and 6, Mr.
And
M.K. Sharma, for N.K. For respondent number 4, 5, and 6. And Mr. R. Sharma, learned senior counsel assisted by learned amicus curiae. Amicus curiae. Mr. Sharma submits that the matter may be listed on 10th of March. Yes, he could not go through the case file, which is voluminous in nature. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that Justice list the matter on 10th of March as top of the list item.
Obliged.
Obliged.